Good afternoon, everyone. I'm Russ Feingold, the president of the American Constitution Society, and I'd like to welcome you to today's briefing call, Tinkering with the Machinery of Death, Resuming Federal Executions. As sober of a subject as this is, I am pleased that well over 400 people have registered for this, including two old friends and allies on the death penalty issue, Steve Rohde and Mike Farrell. It's great to be working with you again. In just a few short days, the United States federal government will apparently begin what will be the quickest succession of executions in the history of the modern federal death row. 3 men are scheduled for execution. Daniel Lewis Lee on July 13th, Dustin Lee Honkin just 4 days after that on July 17th, and Keith Dwayne Nelson a month later on August 28th. Another man, Wesley Perky, was previously scheduled for execution on July 15th, but has been granted a brief temporary stay as his claim of ineffective assistance of counsel is being considered by the Seventh Circuit, and a further violation of a religious liberty claim on behalf of his spiritual advisor makes its way through the courts. In any event, this summer of executions, if allowed to move forward, would more than double the number of people executed by the federal government since the federal death penalty's reinstatement in 1988. Only 3 men have been executed in the past 3 decades. As some may recall, all but Mr. Nelson had previously been scheduled for execution this past December or January. And perhaps as alarming as the unprecedented pace of the scheduled executions is the Department of Justice's lack of justification for resuming executions so quickly, and in the face of serious systemic concerns and concerns particular to the cases of each of these men. Relying on the DC Circuit's decision to vacate an injunction against the proposed execution protocols, which the US Supreme Court has declined to review, Attorney General Barr has insisted on moving forward, despite serious issues that reflect the systemic problems in the death penalty, including concerns about junk science, mental illness, ineffective representation, lack of appellate review, and arbitrariness. But before we get to our discussion of these alarming developments, we do have the great fortune of hearing from a gentleman who knows firsthand the injustices of the death penalty in the United States. Gary Tyler is a former death row inmate who now works to help homeless youth. Gary, who is Black, was just 17 when he was convicted of first-degree murder by an all-white jury and sentenced to death. He was sent to one of the most notorious prisons in the United States, the Louisiana State Prison in Angola. So I'm very honored to invite Gary to share his story with us today.
My name is Garrett Allen, and I'm a former death row / juvenile lifer who has spent 41 and a half years of his life in prison on a trumped-up murder charge. On Monday, October 7th, 1974, I was 16 years old in the 10th grade when I was falsely accused of shooting a gun off a school bus loaded with Black students that were being evacuated from Destrehan High School because of a race riot. That fateful day, a 13-year-old white student was shot and later died in a local hospital from a gunshot wound. After protesting about the way we were being treated by the St. Charles Parish police officers, I was immediately singled out and arrested for disturbing the peace and interfering in the officer's duty. I was transported to the police substation where I was viciously and brutally beaten by several white police officers who tried to coerce me to sign false statements against other Black students on the bus. When they couldn't get me to agree to sign any of their false reports, they got infuriated and began beating me more until my mother and father demanded to see me. The following morning, I was transported and officially charged with first-degree murder of the death penalty of first-degree murder of the death of 13-year-old of the 13-year-old student at Destrehan High School. I was indicted, tried as an adult, and convicted in November 1975 of capital murder by an all-white jury, and automatically sentenced and scheduled for execution May 1st, 1976, to die in Angola's electric chair. I was the youngest person on death row in the United States when I entered Angola. The prison was infamously known as the worst and bloodiest prison in the nation. I entered a place never knowing whether I would survive. Prison life was cruel and inhumane. Prisoners were forced to live in culture of violence. I was in a place where I did not know anyone. I was physically, emotionally, and psychologically unprepared to deal with what lies ahead of me. My ultimate challenge was how I was going to survive and navigate in a volatile environment that was cruel to everyone. However, in spite of it all, what truly resonated with me at the time was a famous quote I remembered by Martin Luther King. He stated, "The ultimate measure of a man is not where he stands at a time of comfort and convenience, but where he's at a time of challenges and controversy." It was a tall order to accomplish for a young man who was ill-equipped. After a few days on death row, hearing and seeing a prisoner engulfed in flames as he mercifully cried out for help in a locked cell, the men on the tier where I was confined, one by one, came out during shower hours to introduce themselves. It was a sign of solidarity. They wanted me to know that they had my back. The men recognized the precarious situation I was in. I was very young in a bad place that was known for destroying people's lives. On June 16, 1977, after being on death row for 18 months, the United States Supreme Court ruled in Roberts versus Louisiana that the implementation of the death penalty law in Louisiana and several other southern states were unconstitutional under the 8th Amendment and 14 Amendments when it made capital punishment mandatory. After several months of litigation, the Louisiana Supreme Court ordered the lower court to resentence me to life in prison, where I remained for 4 decades. As a young man whose life was in peril, I realized how arduous my journey would be fighting against a draconian, racist criminal justice system, the same corrupt criminal justice system that has disproportionately discriminated, incarcerated, and given the death penalty to Black people and people of color. Also, let's not forget the same American criminal justice system in 1944 who arrested and tried 14-year-old George J. Steiner on trumped-up first-degree murder charges and executed him in an electric chair over 70 years ago. The criminal justice system hasn't changed. It's still the same, and we must diligently work to change this institution to serve the people. On April 29th, 2016, I was finally released from prison, and I humbly speak before you as living proof that there are good and decent people in prison, men who stood up and faced danger to sacrifice their lives to assure my safety. They gave me the best of themselves so that I can persevere and overcome adversities and challenges. It has been 4 years since I left Angola, and the conditions inside the prison have drastically changed for the worse. COVID-19 has had deadly consequences throughout the institution. It has been reported that the coronavirus have taken the lives of 17 imprisoned men, most of them I knew inside the prison. One in particular was a close friend of mine who was on death row with me in the 70s. His name is Michael Williams, 70 years old. He died May 18th of this year, having served 45 years in prison. My condolences goes out to his family and every family members throughout the United States who lost a loved one inside and out of prison due to this dreadful pandemic. Thank you.
What a powerful and appropriate way to start this conversation. Thank you so much, Gary, for sharing your story with all of us. The strength and positivity of your spirit, despite such harrowing experiences, is truly amazing. So thank you. Now I'd like to turn to this afternoon's discussion, but first just a few housekeeping notes. Today's call is being recorded, and the recording will be available after the call on ACS's website at www.acslaw.org. We'll be taking a few questions after our presenters are finished with their remarks. If you'd like to ask a question, you can type it into the Q&A box at the bottom of your screen at any time during this call, and we'll try to get to as many questions as possible. Finally, 1 hour of California CLE credit is available for this call. Please email us with Tinkering with the Machinery of Death in the subject line at info@acslaw.org to receive your certificate. If you're seeking CLA credit in a jurisdiction other than California, please consult the rules of that state CLE board to see if it provides for reciprocity with California. CLE materials can be found on the event page of the ACS website and will be shared with all the participants in a follow-up email. Now, today we're joined by two of the leading experts in the death penalty in the United States, both with particular experience with the federal death penalty. We'll first hear from Miriam Gohara, the Clinical Associate Professor of Law at Yale Law School. Professor Gohara spent 16 years representing death sentence clients in post-conviction litigation, first as an assistant counsel at the NAACP Legal Defense Fund, and then as a specially designated federal public defender with the Federal Capital Habeas Project. Professor Gohara teaches and writes about capital and non-capital sentencing, incarceration, and the historical and social forces implicated in culpability and punishment. Our second speaker is Megan McCracken, Eighth Amendment Resource Counsel. Megan is an experienced capital litigator with expertise in challenges to lethal injection as a method of execution. She provides litigation support and expert consultation to attorneys who are challenging lethal injection practices in jurisdictions across the country. Megan was previously an assistant federal defender in the Capital Habeas Unit of the Federal Community Defender in Philadelphia. So let me start with Professor Gohara. Let's start with you. Could you just share with us some of the concerns raised in these cases that are coming up and how they relate more broadly to the systemic concerns regarding the federal death penalty?
Sure, I'll be happy to. Thank you for the question. Thank you for the invitation and the introduction. Let me just start off by saying, since we did get the benefit and pleasure of hearing Mr. Tyler speak, that to put this in federal death penalty and the upcoming federal executions in context, the federal government is far out of step with the rest of the country on the death penalty right now. 10 states in the past decade have abolished the death penalty in law or in practice, the most recent being Colorado this year. And according to the Death Penalty Information Center, as of January of this year, 2/3 of the United States have either abolished the death penalty or have not executed anyone in the past decade. In 2019, the use of the death penalty remained at near historic lows, as the states conducted fewer than 30 executions and imposed fewer than 50 new death sentences for the 5th year in a row. That is a drastic reduction from the time when I started doing this work in the late 1990s and early 2000s, when the death penalty, both in terms of sentencings and executions and public support, were at an all-time high. And I should mention that this national move away from the death penalty is genuinely bipartisan and includes concerns from people on the range of the political spectrum about the death penalty's cost, its fairness, the risk of executing an innocent person. We know that over 170 people have been exonerated who were formerly on death row and sentenced to death in this country. And so just by way of background, to tie in with some of the systemic injustices that Mr. Tyler referred to in his own experience, that is the context in which the federal government is seeking to resume executions at a time when the death penalty is in decline in most of the states. So from here, I'm going to talk a little bit about the general overview about the federal death penalty and debunking some myths that I think attach to the federal death penalty. I'm going to explain in some more detail some of the opposition to the upcoming federal executions, and I'll give a little bit of background about each of the 4 cases that were slated for execution, 3 of which are still very much moving forward at this time. First, one of the major myths about the death penalty is that it's a nationally imposed and uniformly imposed penalty, and that the federal death penalty is somehow national in scope. That is not true. The federal death penalty, just like the state death penalty, has hot spots. 3 states, Virginia, Texas, and Missouri, are responsible for nearly half of all federal death sentences. And 3 federal circuits that include those states, the 4th, the 5th, and the 8th, account for 43 of the 62 current federal death sentences. Only 1/3 of the 94 federal judicial districts are responsible for all current federal death sentences. Another myth about the federal death penalty is that it's limited to a small universe of cases in which the crimes posed a particular threat to national security. That is not true. As I mentioned at the beginning, when the death penalty in general was at its high in the late 90s and 2000s, that was in part as a result of decades of tough on crime policies, including an expanded federal crime bill that now, in many respects, and again, through bipartisan opposition, has fallen largely out of disfavor. And it is in that context in which the federal death penalty has expanded significantly. I see you nodding your head because you know that history quite well, I'm sure. And so what we know is that only 1 person on the federal row of the 62 people who are currently facing federal execution is there for a terrorism-related crime. Everyone else is there for a crime that either could have been, or even in some cases was, prosecuted by the states. And those include cases that involved kidnappings or bank robberies, cases without a clear federally compelling interest. And the way those cases become federal is that the government can argue, for example, that a bank that was robbed was federally insured, or that a car that was used in the kidnapping was traded in interstate commerce or crossed state lines, or a crime took place on federal property. Maybe it took place in a federal park or on a Native American reservation. Those are the ways in which most of these cases, all but 1, in fact, have become federalized. So many of the prisoners on federal death row, in fact, most, are there for crimes that have nothing to do with protecting a general federal interest and security. Another myth, the federal government is certainly not the gold standard that it has been portrayed to be in many instances. The federal death penalty reflects many of the same systemic injustices and racial bias that are widely acknowledged in the state death penalty system. And I'll say right at the outset that the 4 men who are slated to be executed, again, recognizing that 1 has received a temporary stay, are white men. That is a cynical move by the federal government to distract from the underlying systemic injustices that plague the federal death penalty system, just as they plague the state death penalty system. And I'll talk about that more in a few minutes. But 35 of the 62 people who are currently federally death sentenced are men of color, and 26 are African-American men. There are people on the row who were sentenced by all-white juries. One of the ways in which the federal death penalty skews racially is that although a crime may take place, for example, in a city like St. Louis, which is over 50% African-American, if that crime is prosecuted in the federal judicial district instead of in the city in which the crime took place, the federal judicial district jury pool is going to draw from suburban, exurban, and rural communities that are not in the city. And of course, as we know, many people leave the city many white people leave the cities for various reasons, including an active desire to live in homogenous communities and send their children to homogenous schools. Those are the people from which the federal judicial districts can draw their jury pools. And so it is much more challenging to have a diverse jury pool for people who have committed crimes in cities when they're prosecuted federally. And as is the case of the 3 people who are on federal death row from the Eastern District of Missouri, which includes St. Louis, at least one of them was sentenced by an all-white jury. Let me go back to the fact that these 4 white men are the first to go. This is a choice that the federal government has made, again, which is beside the point and distracting to the facts of systemic racism and injustice in the federal death penalty. In addition to that, as I'll describe when I talk a little bit more about the specific circumstances of each of these men, each of them have suffered the very same impacts of lifetime poverty, divestment in their communities, disparities in healthcare, disparities in education, lack of opportunity, and systemic failure that all people who have been death sentenced in this country that I've ever known anything about have experienced. So their race, in some respects, is really a distraction and beside the point. Furthermore, it's extraordinary that the federal government would seek to execute these men at a time when people are crying out and literally putting their lives on the line in the middle of a global pandemic to march in the streets, to raise questions and concerns and demands for reforming our criminal legal system, all of the problems of which come to a head in any death penalty prosecution and conviction. One last myth I'll debunk concerning the federal death penalty is that the people on the row are the worst of the worst. They are not. As I just mentioned a few moments ago, these are men who have grown up under extremely adverse circumstances. Again, entrenched poverty, abandonment, neglect, physical and sexual abuse, mental illness. There are people on the federal row who suffer from intellectual disability, even though the Supreme Court held unconstitutional the execution of the intellectually disabled in 2002. Many of these men were sentenced by juries who lacked essential information to which they were constitutionally entitled to have their capital sentencers consider. And so these are conditions that, as I mentioned, the people who are out putting their lives on the line and protesting against criminal legal injustice in this country are concerned about. These are the very conditions: disparities in healthcare, disparities in education, divestment in communities, regardless of the race of the defendants who are involved. There is widespread opposition to these executions. People from across the political spectrum and from a range of backgrounds are urging the federal government not to move forward. More than 300 former correctional officers, current and former prosecutors, and former judges, and the families of people who have lost loved ones to homicide have called on President Trump and Attorney General Barr to halt these executions, including the surviving victims in Daniel Lee's family. He's the first man who's slated to go forward next Monday, and I'll talk a little bit more about them in a few moments. Just yesterday, Daniel Lewis Lee's surviving victims and faith leaders filed a lawsuit urging the federal government not to go forward and asking for an injunction in order for them to be permitted and able to witness these executions as they otherwise would be, but can't under the current conditions of the COVID pandemic. So these are not people who one might normally think would oppose the death penalty, but in this case, they do. Let me talk briefly about I wanted to say something about this statement that the faith leaders made because it was quite powerful. It's just a very brief statement. What they say is that during a time of global pandemic and when the nation is grappling with economic crisis and systemic racism in the criminal legal system, and here's a quote, "We should be focused on protecting and preserving life, not carrying out execution." And again, this was signed by over 1,000 faith leaders in this country. This was a letter that's separate from the lawsuit, which 2 spiritual advisors and victims' family members in Danny Lee's case have a lawsuit in which they filed to stop the government from moving forward. So let me say something about Danny Lee. He is the first man. He's scheduled to go forward on Monday. He was a young man who was abandoned, essentially left in a seriously misguided situation, grew up under extremely adverse conditions, lived in a group home for parts of his life, and essentially was seeking guidance and family. And he fell in line with a group of older people, a group of older men who were part of a family who were at the time espousing white supremacist views. So the federal government will say that Danny Lee is a white supremacist. That is not true. He long ago renounced any ties to any white supremacist organizations. The federal government will also say that he murdered a child. That is also not true. The prosecutor's own evidence showed that Danny Lee refused to kill the child in this case, and his more culpable co-defendant actually received a life sentence while he is sitting on death row. And finally, in what's possibly an unprecedented set of circumstances, the victim's mother and grandmother and sister, as well as the judge who presided over Danny Lee's federal trial and the prosecutor who prosecuted it, have all urged the government not to move forward with his execution, have all said that he was wrongfully convicted on junk science. So there are serious problems with his case. There are procedural reasons why those problems have not been adequately considered by the courts, and he's just the first of the four men. Mrs. Earlene Peterson, who is the grandmother of one of the victims and the mother of one of the other victims, she's a President Trump supporter, and she has urged the president by video, by letter, and now in this lawsuit that I mentioned, not to move forward with this. Wesley Perky is a gentleman who has received a brief and temporary stay. Wesley Perky suffers the combined effects of schizophrenia, Alzheimer's disease, and dementia. And he does not have a cogent understanding of why he's being executed. He believes that his execution is part of a large-scale conspiracy against him by the federal government. His life was also marked by horrific abuse and awful childhood circumstances that have now been compounded by mental illness and dementia. Again, it's unconstitutional to execute somebody who cannot understand that they're being executed and is not competent to be executed. Dustin Honkin is a person who has served 12 years in solitary confinement on death row. He is a Catholic. He's deeply remorseful. He has a spiritual advisor who would like to be present at his execution and who will not be able to if this execution moves forward at this time because of the COVID pandemic. He also was severely abused and neglected as a child. These men all have these circumstances in common, and it's not an accident. Social science tells us that when people are harmed in their early lives, they are at risk of developing mental diseases and of harming other people. And the last person is Keith Nelson. Again, he's someone whose jury lacked basic information, again, to which he was constitutionally entitled to have his capital sentencer hear and understand before deciding whether to sentence him to death. And he was subjected repeatedly to childhood sexual and physical abuse and a multi-generational history of mental illness. These are the men who the federal government has slated to move forward with execution in this rushed circumstance at a time when the pandemic makes it challenging even for their legal counsel to engage with them in person. So I'll pause there because Megan has very important information and context on the lethal injection challenges.
Professor, what an efficient job of raising and then exploding these myths that really do exist with regard to the federal death penalty and the death penalty in general. It's very helpful. And I will turn to Megan. Professor Gahara has just given us a broad picture of the historic and current problems with the federal death penalty. I'd like us to drill down now on one of these problems. We've alluded to the near 20-year moratorium on federal executions that will end if executions move forward this month. What do lethal injection proposals have to do with this moratorium? If the courts are allowing DOJ to move forward with executions, have the issues with the protocols here been resolved?
Well, the very quick and easy answer to your question is no, but I will elaborate. Thank you, Russ and Miriam, and especially Mr. Tyler for his very powerful remarks. As Russ and Miriam have explained, there have been no federal executions for almost 2 decades. And then last July, the Department of Justice announced a new execution protocol and simultaneously set 5 execution dates. That was July 25th last year. Since then, the government has pushed to move forward with executions despite ongoing litigation, both related to the protocol itself and then related to many other issues for the 5 and then 4 and now 3 men facing execution. And that consistent pressure to carry out executions, perhaps paradoxically, has prevented the courts from reviewing the constitutionality and the legality of the new execution protocol. So first, I'll just address what the new protocol is and then talk about how the litigation and the protocols relate to the break in executions, the absence of executions, and relate to now this current rush to execute. So if the scheduled executions go forward next week and then in August, the Bureau of Prisons will use a new lethal injection protocol, new to them, which calls for administration of 5 grams of pentobarbital, which is a barbiturate drug. So I want to take one step back and say, not only were there no federal executions in the past 17 plus years, there were no federal executions from 1964 until 2001. And then in 2001, there were 2 executions, Timothy McVeigh and Juan Garza, both in June of that year. And then 1 execution in March of 2003 was Lewis Jones. And then there have been no federal executions since 2003. During this period of de facto moratorium, there have been many developments with lethal injection. So first, in December of 2005, several federal prisoners filed a lawsuit challenging the lethal injection procedure that was in place at that time. That litigation moved forward for many years. Like all litigation, there's a lot going on. So there were motions, there were appeals, there was briefing, there were new plaintiffs. The case actually got put on hold twice because 2 cases, Hill and then Bays, went up to the Supreme Court. But then it got going again and went into discovery. At that point, the government's execution procedure called for 3 drugs. It was serial administration. The first drug was a barbiturate called sodium thiopental, and that drug was intended to put the prisoner under anesthesia. The second drug was a paralytic, so intended to prevent all movement, and it was called pancuronium bromide. And the third drug was concentrated potassium chloride that would stop the heart. The drug that's most relevant for our purposes of discussing what was happening with the protocols and how does that relate to the break-in executions, that's the first drug, thiopental. That drug was manufactured and marketed by one company in the United States called Hospira. It's very easy for me to go way too far into the weeds on this. I'll try not to, but one company made this drug. And in 2010, that company had a very bad inspection by the FDA at their manufacturing plant in North Carolina. It was so bad that rather than fix the problems at the plant, they closed the plant. They briefly explored other options for producing thiopental, but then in the end never returned to market for it. And the reason why I go into those details is to say that thiopental became unavailable in this country for all purposes. So this was not related to executions. Thiopental is unavailable for medical use, just as it is unavailable for executions. So starting in 2010, states that were carrying out executions started having trouble getting thiopental, and by 2011, it was essentially unavailable. So in January 2011, attorneys general from 13 states wrote a letter to Attorney General Holder seeking assistance from the federal government to get thiopental, and specifically saying to the federal government, give us some of your thiopental. So several weeks later, now we're into March of 2011, Holder responded to the letter saying that the lack of availability of sodium thiopental was a serious concern and that the federal government was analyzing it. In that letter, Holder announced that the federal government did not have thiopental, so it couldn't give any to the states. That makes sense, of course, because the federal government hadn't carried out any executions since 2003, and this was 2011. So there would be no reason for the government to have had a reserve of thiopental. But then the letter went on to say that the federal officials who were tasked with implementing the federal death penalty had undertaken a review of the matter, and that they were exploring all options, including necessary changes to the federal protocol. That information in the letter was the first time that the plaintiffs in the federal lethal injection litigation were alerted to the Bureau of Prisons revising or considering revisions to the 3-drug protocol. So The plaintiffs went to the court seeking discovery regarding revisions to this protocol, and all of that information came into the litigation. Not that it was that much information, but just that the Bureau of Prisons did not have the drugs and that they would be exploring revisions to the protocol. So now we're in July of 2011. The government asks the court to essentially stay the litigation and while they revise the protocol, and the government agreed to file periodic updates with the court about the revisions and agreed that when they had a new protocol ready to go, they would provide it to the plaintiffs and set up a new discovery and briefing schedule. That was July 2011. For months, which turned into years, the government was filing periodic status updates, essentially saying we are working on the protocol, we are revising it. There was a period of time when the government said they were in the final stages of finalizing the protocol, and yet many years passed. Finally, in July last year, July 25th, the government announced its new protocol, the 5 grams of pentobarbital. It announced the protocol by press release and simultaneously set 5 execution dates. So to be clear, the government knew lethal injection litigation was ongoing. It knew the case was on hold. It knew it had a duty to inform the court and the plaintiffs of the new protocol in order to get the discovery and briefing schedule back on track. But once it had this revised protocol ready to go, what it did was issue a press release and immediately set 5 execution dates. And since that time, again, they have been pressing to move forward with those execution dates, which creates pressure on the courts and chaos for the prisoners, because once you have an execution date, there are so many requirements with just everything, litigation, clemency, to go through, all the while knowing that this lethal injection litigation is still going on. So the litigation did move forward. Last fall, the prisoners who had execution dates secured a preliminary injunction in the trial court. And that was based on a claim that the new protocol is an ultra vires regulation, which means it violates the law. It violates the requirements of the Federal Death Penalty Act. That statute requires that a United States Marshal supervise implementation of the death sentence in the manner prescribed by the law of the state in which the sentence is imposed. So that's a federal statute with a federalism aspect to it. Once the preliminary injunction was ordered, the government moved immediately to vacate or stay the preliminary injunction. And when they lost on that effort, they then appealed the injunction. And so the litigation has moved forward, and it's been up on appeal in the district court. Cert went up to the Supreme Court, but it was just on this one issue. The Court of Appeals reversed the injunction, and that was a ruling that garnered 3 different opinions about the proper way for the government to implement its new protocol in accordance with federal law. And so while that issue has been resolved and is no longer part of the case, many questions remain given this splintered opinion about how does the government now implement this new procedure and remain in conformity with the law. While the cert petition was pending up at the Supreme Court, the government reset 3 execution dates and set a 4th new execution date. The 3 execution dates that were set about 20 days out from the time of notice, which again is just an extraordinarily small window of time, given everything that needs to happen in between notice of an execution and the date itself. So again, so much rush and so much pressure. All the while, the plaintiffs in the lethal injection lawsuit were working back in the trial court, and they filed an amended complaint on June 1st that contains now 9 claims that still have not been reviewed or addressed by any court. So the preliminary injunction issue was based on 1 claim. The Court of Appeals ended up addressing 2 claims. So the ultra vires and then also an Administrative Procedures Act claim regarding whether or not the protocol was the type of regulation that has to go through notice and comment. They said no. But there are still 9 claims left that the court hasn't had a chance to review. There's been no discovery, and they have execution dates set next week and in August. The remaining claims address the 8th Amendment problems with the new protocol, the 1st, 5th, and 6th Amendment problems with the new procedures, and then various violations of law under the Controlled Substances Act, the Food, Drug, and Cosmetic Act, and the Administrative Procedures Act. So I know I just rushed through this all very quickly, but that is sort of everything that has happened since 2005 with regard to, sorry, dogs, lethal injection litigation, lethal injection protocols, and now this rush to execute, despite the fact that none of these legal claims have been addressed.
Hey, thank you. You know, that is a fair amount of technical material, but what was so powerful was you showed the sort of craven nature of the government's desire to just move this forward. You know, they instead of regarding these concerns as legitimate questions that have to be answered when you're dealing with an irreversible penalty, it has this feeling of a terrible rush to judgment, a craven rush to judgment, and it's important for people to realize this pattern that's emerged. We now have a little bit of time for questions. I'm going to ask a few that we here at ACS have prepared, but we also have some questions from the audience. So let me start off with both of you, or either of you respond to, you know, what's the danger basically of scheduling these executions in such quick succession, especially with a new protocol about which concerns already exist?
Sure. So, I mean, I think that that's a great question, and the concerns with having so many executions so close together are many. I mean, first, as Miriam alluded to, there is a global pandemic, and bringing so many people into a small space, we're talking about Bureau of Prisons personnel, outside contractors, attorneys, spiritual advisors, citizens, family members, all of these people, bringing them all together into a small space, that is a health risk that, I mean, I think that we can't understate in any way or overstate, you know what I'm trying to say. But what we've seen in the past with executions is that scheduling them close together puts an extraordinary amount of pressure on the execution team. And so we've seen in Ohio, in Arkansas, and in Oklahoma that when you schedule executions close together, mistakes happen. And in the botched execution of Clayton Lockett in Oklahoma, afterwards, when they were interviewing the medical team that was responsible for setting the IVs, they specifically said they felt so much pressure that night because they knew they had an execution to do immediately after Clayton Lockett's execution. And so that they were worried about getting this IV set really quickly. So that's just literally pressure to get it done and get it done right because you know you have to do another one. But then there's also the psychological and the emotional toll. You know, they set 3 executions in 1 week. In other states that have reviewed problems, botched executions, they have specifically said to always schedule executions minimum 1 month apart because of that toll it takes on the execution team. And you know, I think again that that's a very serious consideration, that we should just think of the human impact on everyone involved.
Miriam?
Yeah, I couldn't agree more with everything Megan said. And the problem is that what we know is that executions have a very debilitating and demoralizing effect on correctional staff as well. Not only the people who carry out the executions, but for better or for worse, there are men and women inside these prisons that interact with incarcerated people every single day. And these executions are going to take a toll on every single person who knows these men. And in addition to that, again, there are people who otherwise would be permitted, if not entitled, to attend these executions who cannot travel. Mrs. Earlene Peterson, I believe, is over 80 years old. She's asking to be able to be present, even though she vehemently opposes Danny Lee's execution. She vehemently opposes it because she does not believe that it's going to help matters. She thinks it's going to further traumatize her family, but she wants to be present. And if it is going to go forward, and she cannot do that. And the spiritual advisors, again, these men would otherwise be entitled to have spiritual advisors with them and by their sides at the time of their death, and they are not going to be permitted to do that. Another myth, I guess I can debunk is, you know, people might think, well, why does it have to be safe? People are going to be dying anyway. They're going to be killed. You know, why is it that a protocol needs to be safe? Well, the country, you know, has the Constitution requires that a punishment not be cruel and unusual. Now, some of us believe that the death penalty is inherently cruel and unusual, but even if you don't hold that view, having someone be tortured, which unfortunately witnesses to botched executions have suggested is the case, when people are paralyzed. Megan cogently explains the impact of these drugs. When somebody's paralyzed but cannot speak and cannot express the excruciating pain that they might be experiencing, that is torture. And many people of good faith, even those who might support the death penalty for other reasons, would agree that that should not be permitted. And these are the risks that are heightened, especially when executions are rushed.
Thank you, both of you. Let me try another question. By some counts, more than half of the people on federal death row were sentenced after the moratorium on executions began in 2003. Have any of the concerns regarding the process by which cases are chosen for capital prosecution or the processes afforded people facing execution been addressed in that time? You know, assuming it's possible to fix any of the problems with the death penalty, has the federal government really taken the opportunity to do so?
President Obama's Justice Department had expressed deep concerns about the death penalty and had said, especially after the botched execution of Mr. Lockett in Oklahoma, that they wanted to undertake a study. The Department of Justice wanted to study what was happening with the death penalty nationally. Presumably that would have included the federal death penalty. And we don't know what became of that study. The Trump administration's, the Barr Justice Department certainly doesn't appear to have pursued any of those investigations or questions about some of the deep concerns about the carrying out of the death penalty or the imposition of federal death sentences. And so we don't know where that stands. What we do know is that now is a time when the public is crying out for serious examination, reform, and abolition of many aspects, the most brutal aspects of our criminal legal system. And certainly the death penalty has to stand as one of the most unjust and brutal aspects of our criminal legal system. So again, how out of step with the rest of the nation does this administration need to be to insist on moving forward with these executions at a time when people are saying, hold on a minute, we're willing to call into question many aspects of our criminal legal system that people have taken for granted for decades and centuries. Not often the people who are most oppressed by those systems, but certainly by majority populations who tend to believe that they make them safer.
And in that regard, let me follow with another question. Of course, as part of the reason that I and the organization have chosen to highlight this, it's partly because of the immediacy of the new possible executions, but it's obviously the racial injustice aspect that has been essentially inherent in the death penalty. And so I'd like you to both comment on, are there problems with the death penalty that we're talking about today that are unique to the federal system? What about those states that continue to sentence and put people to death, in particular, focusing on the racial composition of the people on death row that you already talked about on the federal level? Megan?
Well, this is not my area of expertise. But I would say that, I mean, the problems that we see with the death penalty are across the board. We see them in the states and we see them with the federal death penalty. And, you know, when I'm looking at lethal injection or when we're looking at any aspect of the death penalty, as soon as you scratch the surface of that problem, and particularly with racial injustice, you know, you just uncover the flood. As Miriam mentioned earlier, you know, it is strategic and deeply cynical that the first execution dates are set all on white men, because that does, I mean, I guess I see it very cynically. It not only seeks to obscure the reality of the federal death row, but also plays into current climates and the current uprising to bring change and bring attention to racial disparities in criminal justice. But let me hand off to Miriam, who knows much better than I do.
Thank you, Megan. Miriam, yes, you alluded to the states pretty significantly in your comments. Could you talk a bit about this?
Well, I mean, the three biggest feeders to federal death row, which are Texas, Virginia, and the Eastern District of Missouri, all have serious racial skews in their state death penalty. That's well known, but also in their federal death penalty. So in Virginia, all of the federal death sentences handed down in the modern era have been against men of color. In 75% of people from Texas who have been sentenced to federal death have been people of color. And all of the people sentenced to death from the Eastern District of Missouri have been men of color. And again, at least one of those was sentenced by an all-white jury for the reasons that I explained earlier. So this is absolutely a problem. And the issue with going forward, again, and opening the door to 4 executions in rapid succession means that all that's going to do is open the door to many more executions to come by the federal government. And the composition of federal death row is disproportionately people of color. Again, 35 of the 62 people on the row are people of color, and 26 of those are African-American men. So simply executing 4 white men whose trials and backgrounds were plagued by all of the same injustices that have harmed people historically, who've been subject to the death penalty for time immemorial in this country, is going to do nothing but open the door to further punishment and pursuit of execution against men of different hues.
Great. And I want to just follow up on a little bit more on this geographic issue, geographic disparity that you've been talking about in terms of Texas, Missouri, and Virginia accounting for nearly half of all the current federal death sentences too. Assuming that these 3 states are uniquely beset by death-eligible crimes, how does the accident of geography play into the arbitrariness of the federal death penalty? And how might that play into challenges to the federal system? Is this another interesting area of argument with regard to the death penalty? Miriam?
Well, the federal death penalty is supposed to be a national punishment, right? It's the same statute that makes people death eligible in any part of the country. And yet, because of the same issues related to prosecutorial discretion that have made the state death penalties arbitrary, they are similarly arbitrary in the federal system, because the way the federal prosecutions move forward, of course, is that even though it's the Department of Justice that's doing the prosecution, it's the local U.S. attorney's offices in the federal district that are pursuing those prosecutions. Sometimes they'll bring in lawyers from federal DOJ, national DOJ, to support the litigation, but it's the local decision makers. It does go to a capital case unit, and there's been litigation against the people in that unit for other problems that have brought to light some serious concerns about the process by which they have decided who to pursue capital charges against. But ultimately, it's the local prosecutors who decide whether they even want to recommend a federal death prosecution to the main DOJ. So that is geographic. It involves disparities. It involves local decision-making and local legal culture. In addition to that, disturbingly, there are people on federal death row from many states that have abolished the death penalty. Iowa, Dustin Hunkins from Iowa, his crime took place in Iowa. That's a state that hasn't had the death penalty for many generations. Michigan, Massachusetts, North Dakota. So the federal death penalty in some respects is overriding the will of local people whose legislatures or judges or somebody in their states long ago decided the death penalty was not an appropriate punishment and was not the norm that they wanted to set in their area. And yet somehow the federal government is overriding that. I would think that would be a very serious concern for people who are concerned about local control for various reasons.
Well, I really like that answer, and it relates to my promise to go to the questions from the audience at this point. You know, I happen to be from one of the 2 states that hasn't had death penalty since before the Civil War. I'm very proud of that. And so this question you just raised was actually asked first in the audience by Steve Rohde, and you've already started to answer it. Of the 62 people currently on federal death row, are any from states which have abolished the death penalty? You just gave examples, but can you just go over that a little more carefully? Because certainly I remember on occasion wondering how it could be that a Wisconsinite could be subjected to the federal death penalty when we don't even have it in Wisconsin.
So the states that I can think of off the top of my head from which I know there are federal there are people serving federal death sentences are the ones that I just rattled off: Michigan, Massachusetts, North Dakota, Iowa. I believe there are others, and Illinois. These are, again, why? These are crimes, all of them. Not one of those cases that that I have in mind right now involved a terrorism-related crime. There was one case, infamous case out of Massachusetts, that involved a terrorism-related crime, but there are another person on federal death row, had nothing to do with terrorism, who's there from Massachusetts. And the question is, why did the federal government decide to pursue those prosecutions? Well, sometimes the answer is, very similar to the reasons that there's been disparity in the state death penalty. There is disparity in which victims' lives are valued. There are ways in which local law enforcement actors decide that they want to bring to bear the resources of the federal government for some reason on behalf of some people and not others. As we all know, unfortunately and tragically, homicide is a very serious problem in this country. The vast majority of cases never get solved, but those that do and are prosecuted don't end up with capital prosecutions or punishment. And so then there has to be a reason that there's disparity and decision-making that decides to put to bear a set of resources against certain defendants on behalf of certain victims and not others. And that is going to result in the kinds of skews that we're seeing here in terms of race and geography that now exist in the federal death row, reflected by the population of federal death row.
Megan, did you have anything you wanted to comment on that question? Okay, well, let me take a question from Seth Kretzer. How do ineffective assistance of counsel doctrines from state habeas corpus habeas apply to the Federal Death Penalty Act? Either of you?
Well, I mean, so ineffective assistance of counsel is a Sixth Amendment claim that is recognized in any criminal prosecution. Any person who's been convicted of a crime can ostensibly raise an ineffective assistance of counsel claim because they are constitutionally entitled to the effective assistance of counsel at their trials or plea representations. And so the same way that it applies to people who have been sentenced to death in states, it applies to federal cases as well. And every single one of the four men that I've mentioned has a ineffective assistance of counsel claims that they've lodged against their lawyers for failure to present evidence to which they were constitutionally entitled to have their jurors and their sentencers consider. Dustin Honkin's co-defendant had her death sentence set aside in part because of ineffective assistance of counsel. And so, as I mentioned, Danny Lee's more culpable co-defendant, who the government's own evidence showed was the one who actually pulled the trigger on the child in the case, it received a life sentence. Clearly, there was some sort of problem in their difference in their quality or level of representation. So ineffective assistance of counsel is a powerful issue. It's one that plagues every one of the capital cases in which I've ever been involved or consulted.
I'll just add that as part of that, I'm sorry.
No, go ahead.
As part of that Sixth Amendment right to counsel, that also guarantees access to counsel up until and through the execution. And, Terre Haute, where the federal death row prisoners are housed, has been closed since early March. And so, again, the government is pushing and pushing to move forward with executions. And counsel hasn't been able to meet with their clients since early March. And talking on the phone and talking by video is not the same. And so that's an access to counsel issue, but it's very real, and it exists because of a real and valid threat to everyone's health, including counsel, the prisoners, and everyone who works in the prisons. And so, huge problem.
We only have time for one more question, but hope you'll help us with it, from Elena Trilling. And it relates to another one of these obvious infirmities of the death penalty. How many prosecutors have been able to successfully circumvent legal precedent barring execution of individuals with intellectual disabilities?
Well, the problem, again, this actually goes back to the issue of ineffective assistance of counsel. If somebody isn't trained properly and doesn't know to look for the signs and symptoms of intellectual disability or other mental disease or defect, then they will not be able to adequately represent their clients with those conditions. And as the Supreme Court recognized in the Atkins decision, people with intellectual disability are at exceptionally high risk of wrongful conviction because of their disabilities interfere with their ability to assist with their own representation. So even if a prosecutor doesn't intentionally pursue the death penalty against someone with intellectual disability, there are too many risks that someone with intellectual disability can be executed and death sentenced. And unfortunately, we know that there are people on the row who do have intellectual disability, and again, whose claims are still pending.
Megan, give you the last word on this or the general topic?
No, I agree with Miriam.
All right, listen, I want to thank both of you very, very much. Look, we've decided at ACS that this is only the beginning of the process of obviously questioning the death penalty overall, but it happens because of the recklessness of the federal government that they have created a moment where we can really get people's attention. We've had hundreds of people on this call indicating a strong concern about this, what is likely to happen next week, but obviously it evinces a much broader concern about the death penalty itself, which you've both illustrated by talking about the enormous change in the attitudes in so many states in recent years. So this is a major moment in the history of this penalty, and we are determined to work with you and all the people on the call to advance the cause that I certainly believed in all my life of the abolition of the death penalty. But there are so many specific aspects of it that you are experts at that we have to get good at and explain to people so they realize the context that these likely executions are occurring in. So thank you very, very much. Thanks to everybody that was on the call. I look forward to this, working with you in the future. Thanks so much.
Thank you so much.
Bye-bye.